Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now see the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Very odd. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Walsh. To my left, Justice Hershfang. We will be hearing 5 cases today. We will take our traditional mid-morning break after the third one. Each side is entitled to 15 minutes. If anyone who's arguing is dividing their time, you need to let us know at the outset. There is no rebuttal. I would say that we have carefully read the briefs and are familiar with the facts of the case in particular. So given the shortness of time, you may want to get right into your arguments. On the other hand, it's your time. You may do with it as you will. So the first case we will hear today is an impounded case. So we will not be using any party's names, and I trust that counsel will be able to adhere to that. It is number 24-1023, Commonwealth versus a juvenile.
Good morning. May it please the court. Dennis Toomey on behalf of the juvenile. One comment before we dive into the stop. What's most concerning about this case in the constitutional sense is how police reacted when the juvenile ran away. Besides chasing him, they physically grabbed him up off the ground, handcuffed him at gunpoint, and Detective Mojica skipped an external pat frisk, stuck his hand directly into the juvenile's pocket, pulled out the belongings, and searched them. Now, if we step back to the moment in time when there was an order to stop, I'd ask you to consider, what if the juvenile had not run? What if they just asked him questions about the loud noises they heard? Would the police still have been able to do those serious physical intrusions I just mentioned, or would that be unreasonable? And if you think it might be unreasonable to handcuff someone and draw a gun and search their pockets at a threshold inquiry, consider the only thing that changed between the order to stop and those actions was the juvenile ran away. But as the SJC has repeatedly told us, in Warren and most recently in Menneus, flight from police, particularly by a minority like my client here, should be given very little, if any, weight in reasonable suspicion calculus.
Okay, but if there was reasonable suspicion to stop him, which I trust we'll discuss as well.
Yes.
That was reasonable suspicion that he had been involved in the discharge of a firearm. How can that not also equal reasonable suspicion that he's armed and dangerous? That is before all of this chasing and everything.
I do agree that the search pat frisk is conflated with the stop order here because of the circumstances. However, I do also believe that the police did not have reasonable suspicion to stop because there was no facts that this juvenile had fired a gun, let alone possessed a gun. Police needed more. Here's what police knew. There was loud noises that may have been gunshots, according to ShotSpotter and an unidentified man on a roof. The juvenile was seen leaving the general area, but no one said that the shots came from the cemetery. ShotSpotter didn't say that, and the man on the roof did not say that was the location of the shots either. So the juvenile is just leaving an area that may be the cemetery. I believe it's unreasonable for police to stop anyone who was leaving the area under those circumstances here. Police needed more. They needed some facts particularized to this juvenile that he committed any crime. Otherwise, police are just randomly stopping anyone who's in the area when a loud noise goes off. Police did not even know if a crime had been committed here.
Well, he had been in a group of 3 dressed in black, and the roofer said that immediately after the shots, it sounds like, or what he believed to be shots, but I think there's reasonable suspicion that they were shots, given both the shot spotter and the confirmatory statement by someone right there that they sounded like shots. 3 people clad in black were running out of the cemetery or running westerly in the cemetery.
It's not a
So
crime.
it's not any person who stopped, it's a member of a group of 3 people dressed in black whose proximity, given the time, might suggest that they were the same people to whom the roofer referred, right?
Well, it's not a crime to be in a group of 3 who are dressed in black, but it's also anyone who heard loud noises, if they thought they were gunshots, would try to get out of the area. So
I agree with that. And if this were, well, I'll ask your brother, but if this were a busy street, then I think it would be difficult to count the running for much because of the likelihood that anyone would run from a gunshot. But it was in a cemetery. Usually they're pretty empty. I don't know about this one. Maybe there was a book fair or something in the middle of it that day. But there aren't too many people around, and these three are running. Oh, and they're masked.
Well,
Masked people generally aren't bystanders.
The mask was not corroborated by police. When police saw the juvenile, he was not wearing a mask.
I agree, by the time they got him, he was not wearing a mask for sure.
And this was a massive cemetery. So this was not the only way to leave the cemetery. It borders many, many different streets. I think according to the map, we're looking at about 100 acres here. Anyone else who was in there who may have committed a crime could have gone a different way. So I think it's unreasonable to stop the juvenile. But even if you believe there was reasonable suspicion to stop, I'd like to turn to the searches because they were not traditional pat frisks here. Detective Mojica skipped an external pat frisk because when he was physically grabbing the juvenile, he bumped something that he thought was hard. So what the SJC said in Silva is, only after the pat-down gives indication that a weapon is present do the police have the privilege to search further. And there's 3 U.S. Supreme Court cases that I believe mandate suppression here. Terry v. Ohio. Everyone knows Terry, but what people often overlook is that in Terry, the U.S. Supreme Court specifically noted that police did not go directly into a pocket. And they explained that the reason we have the pat frisk standard is because that's the balance we've struck. Police using their sense of feel and touch on the external part of a person's clothes versus officer safety. So here, Detective Mojica admitted he skipped that. And the testimony, the question was, could be a cell phone, could be anything, you don't know. Correct, so I just removed it.
But in Terry, there was no indication that there were firearms involved at all. It was a guy casing a storefront. So here, as Justice Rubin commented earlier, the reason the police officer is there is that there may have been a discharge of a firearm. I don't think Terry's great precedent for you. It's a pretty low bar compared to the Massachusetts SJC cases. And also, are you saying that the police officers need to sort of follow this step-by-step, even if he's already felt something by virtue of hauling the juvenile to his feet? That he has to ignore what he has already perceived and go through these motions?
He does not have to ignore, but he does have to follow the steps. Stop, pat frisk, then searching of pockets. And that's what he missed here. And
He's already felt something hard in the pocket.
He did not.
If something hard in the pocket is adequate to fish it out, then he didn't, I agree he didn't do a pat frisk, but he came in contact with the outer clothing, just the same.
The pat frisk could have dispelled any concern, though. If he had actually patted it down, he could have felt that it was a
I
cell
have
phone.
a funny feeling, you'll tell me if I'm wrong, that we have cases indicating that something hard gets to be searched because it might be a weapon, even though we don't feel a handle or or the butt of the gun or the barrel, or you know what I mean, that something hard, you're trying to be safe, you get to take it out and see what it is. I mean, because we have lots of cases where it turns out to be keys to the car that's locked, parked in the parking lot. We have a bunch of cases like that where the thing, obviously, I'm not sure if the court has gone into that, probably if you felt around, you would have been like, oh, that's just keys, not a weapon. Although I guess keys maybe could be used as a weapon, I don't know.
So my argument is that hard by itself is not enough, but also, even if it was ever, that has to be part of a pat frisk, not just bumping into something.
You've totally lost me there. If you've effectively discovered what you discovered during the pat frisk, and if you had done this instead of bumping it with the back of your hand or even the front of your hand, you could reach into the pocket. I don't see how it's a further intrusion.
The pat frisk is what is minimally necessary to feel an object. And the other cases from the U.S. Supreme Court, I wanted to mention Cibron versus New York, 392 U.S. 40, which I overlooked in my brief, but there the U.S. Supreme Court held that it's unreasonable for police to skip a pat frisk and go right into a pocket. And Minnesota
Is
versus...
that a case in which the police officer had already perceived something on the defendant's person?
No, it's not. So I think that is the unique fact in this case. If a police officer inadvertently bumps something but doesn't tactilely pat it down, Is it unreasonable to skip a pat frisk? And that's my argument here. And the third case, Minnesota versus Dickerson, 1993. I believe, Justice Rubin, you may have been a law clerk that year for that case for Justice Souter.
I don't recall Dickerson being decided when I was clerking, no.
In any event, the U.S. Supreme Court talked about how the police have to be immediately aware that it is contraband or a weapon if they're going to go further. And so here again, I don't think—
Isn't that a plain view case?
It's a plain feel case, yes.
Of what?
In that case, I believe it was a bag that they felt. But again, the precedent is, and the holding is, that if police are touching someone's body and they don't immediately feel a weapon or contraband, they're not supposed to go further.
So if I were to kind of agree with your analysis, and we were to author an opinion, in essence, adopting your legal position, the next time a police officer encounters somebody and there's a scuffle, let's say, and they actually, and falling to the ground, can see that there's a gun coming right out of the pocket, you're going to say, should have pat frisked first.
No, I think
Or you felt that when they're going down there,
if they...
now exclude this evidence because they didn't first do something which they've already realized there could be a weapon.
But they had not realized here that it could be a weapon. They need more than just something hard. If
Am
police
I
see a gun,
mistaken, though, that they're not allowed to manipulate the thing to figure out what it is, right?
no, but they're allowed to pat it down. Here's my problem. Let's say you go to the cemetery to put flowers on your relative's grave. There's a loud noise. You say, I'm going to get the heck out of here. You leave. Police stop everyone who's leaving, and they decide to physically seize you. They bump your cell phone in your jacket pocket. And we're talking about jacket pocket in this case, not a waistband. If they had done a pat frisk, they could have seen that it was your cell phone or keys potentially, and then not gone further and searched you on a public street. We're just asking them to do what's minimally necessary, not skipping a step, because that could dispel any concern about weapons.
No, a pat frisk would result in the officer saying, I felt a hard object, which would result in the officer being allowed to then retrieve that object to ensure that it wasn't a firearm.
Well, my position, respectfully, is that they need more than just feeling something hard. They need to have reasonable suspicion that it is a weapon.
Well, so here we have shots fired, right, by the shot spotter and the roofer. So that's where the belief that perhaps this individual is armed and dangerous plays in, right?
I agree that
There's that.
there is
yeah.
that tie in here, absolutely.
Right.
But my position, of course, is that there was no reasonable suspicion particularized to this juvenile, because no one saw him fire a gun, no one saw him possess a gun, no one said the gunshots or the loud noise came from the cemetery where the juvenile was running from.
Do you think Warren means that we can no longer use time and proximity to assess whether someone is the person that someone saw moments before?
No, I think temporal proximity and geographical proximity are still factors, but they're not the end-all, be-all, because innocent people...
No, of course, but it's reasonable suspicion. It's not even probable cause, right?
So how many people could have left that cemetery that police could have searched everyone? Is there a magic number?
In groups of three dressed in black, every group of three dressed in black maybe could have been searched.
Well, with
I mean, right? I mean, that's the actual question. It's not how many people leaving the cemetery. It's that they match the description. Now, it's not much of a description. I agree with that. But in Warren, and you may recall I dissented in Warren here before it was reversed by the SJC. In Warren, we had people, two of whom were in black hoodies and one in a red one, committing a robbery. And then we have a stop of just two people dressed in black hoodies many miles away. I believe one of us in dissent figured out that essentially it was an area the size of Brookline that could have been searched if this was permitted. This is right outside the cemetery. Again, not with any certitude that they left the cemetery, but it's right outside the cemetery, right after it, and they are indeed a group of three dressed in black.
yes, but there was...
I mean, I don't know, you know, it's a question of where reasonable suspicion is, but it's not a dragnet.
I understand, Your Honor, but there was no report that these 3 people committed any crimes. All there was someone heard noises that might have been a gunshot.
If the officer had been inside the cemetery and the 3 people dressed in black with masks on had run into him, could he have stopped them?
If the officer said that, yes, I think that he could have. I think that's what
Okay, so
differentiates.
the only question is, now there's 3 people dressed in black outside the cemetery without masks.
No, the officer would be able to, in that position, to say whether the gunshot came from where those 3 people were. I think that's what.
How would he do that?
If he was there when the gunshot went off. I think that's what differentiates this case. No one said these 3 people shot a gun. No one said the gunshot came from the cemetery. So.
No one said the gunshot came from the cemetery. I feel like your brief said repeatedly they should have searched the cemetery for shell casings or something, right?
That they did not. They did not confirm that a firearm was even discharged, is my point, because the man on the roof had no experience with deciphering sounds as firearms, and ShotSpotter is disturbingly unreliable. So part of my argument is
Is there case law about ShotSpotter being unreliable in this Commonwealth?
only the recent SJC case that suggested that attorneys push that issue more and have Delaware-Lanigan hearings on that. I can see my time's running short. There's no firearm or public safety exception. Police lacked reasonable suspicion, but even if you find they could have done a stop or a pat frisk here, police unreasonably exceeded the scope of a pat frisk and did a search. So if there are no further questions, I will rest on my brief.
Thank you very much. Excellent argument. We will hear next from Attorney Kidd.
Yes, good morning, Your Honors. My name is Rob Kidd. I represent the Commonwealth in this matter. I think I'd like to start with the second issue first, which is the getting the defendant from underneath the car. I would suggest to by the time that happened, don't forget we have the extraordinary act of this defendant. Apparently, as soon as an officer went around the corner in his cruiser, he jumps and rolls himself, underneath the car. The court has to give that some credit. I understand that flight alone is not a factor to be considered, but not only does this defendant flee, but he hides himself underneath the car. Police are now faced with a situation where gunshots were fired in the vicinity, and they've got the suspect of the gunshots underneath the car.
So is that what gives reasonable suspicion that he's armed and dangerous?
I think that under all of the circumstances, yes, I think.
So then how could they stop him in the first place if they didn't have that reasonable suspicion until he rolled under the car?
Oh, they had reasonable suspicion to stop him. I understand that. My understanding of the law is that in order to justify a pat frisk, it has to be reasonable suspicion that the person is armed and dangerous.
And so what were they stopping him for? Reasonable suspicion that what crime had been committed?
That he possibly could have fired the weapon.
Well, reasonable suspicion that something possibly happened sounds like less than reasonable.
No, that's what I meant to say. Yes, that he fired the weapon.
And why couldn't they pat frisk him right then?
They may have pat frisked him right as soon as the cop stopped him. He may have pat frisked him.
And you think that would be okay?
Yes. Yes.
Okay.
I think under the circumstances. I would point out, with respect to the case of Commonwealth versus Warren, Your Honor did point out some important distinctions. I would also point out that Warren involved a breaking and entering case, not a crime involving the imminent emergency.
Yeah, I don't really understand that argument. I saw the judge said that it matters what crime it is, but I thought reasonable suspicion was reasonable suspicion, and it wasn't about the crime, it was about suspicion of having committed it.
But the courts have also said, perhaps maybe talking out of the other side of the mouth, with all due respect, that you have to calculate, you have to consider in the reasonable suspicion calculus the emergent situation of shots fired. That can be considered. So I think the court has to put themselves in the place of this police officer, right? That's what we do, where we're trying to judge whether or not this police officer was acting reasonably. He had a call for shots fired. He had 5 shots that were reported fired. He had witnesses who heard 5 shots go off and saw 3 men in dark clothing running from the cemetery. He encounters one of those 3 men within geographic and proximate location to the cemetery. He wants to make a reasonable inquiry. He only approaches to make the very reasonable inquiry, and I say he has to approach. He has to go up to that defendant, and he has to make sure that he is safe when he does so. He indicates that all he does to the defendant is ask him to show me your hands.
And do you agree that the defendant was seized at that point?
He was, yes, that would have been, show me your hands as a seizure or a stop. I think they're used
So that's different from walking up to him and saying, "Can I talk to you?"
Yes, but, yes, show me your hands as a seizure, yes. But in order to talk to him, it was perfectly reasonable for this officer to ensure his own safety and the public's safety, due to the fact that this person was very close to the scene where shots had fired, and he matched the general description. So doing that, yes, that was the seizure. What was the other alternative? Oh, excuse me, could I speak to you? I suppose the defendant might have, we know that the defendant took off. So I think we know that the defendant, did not want to speak to the police. I would point out that flight is still a factor, even though Warren discounted it in that particular circumstances, and it was in the context of a Boston neighborhood with multiple people of color living in the area, and there was some statistical evidence about persons of color being stopped and so on and so forth. But nevertheless, that is a factor to be considered in this case. I would also point out that the defendant was not described as a black male. That was nowhere in the description, although the booking photo of the defendant could be taken to look as somebody, a person of color. I suggest that the case law supports my argument. There's Commonwealth versus Ducey is a case that I cited. Excuse me. And that was a case that I suggest has, less factors, perhaps, in some circumstances, in some sense, less factors supporting reasonable suspicion in this case.
Do we know how long it took the officer to get to the cemetery?
To the cemetery, no.
Like to the point where he sees them crossing the street is really what I'm
Yes,
interested in.
I can't glean that from the record. Perhaps counsel did. What I read from the record is that he's on patrol. He patrols a certain sector of the city, and he responds immediately to the shots fired, but it does not give us an amount of time that it takes him to get to the cemetery. I can tell you, though, what the officer, after the officer speaks to the roofers, he then puts a radio call out, and then he says, "I drove to meet my supervisor in the area," and he said, and then he used the term 5 to 10 minutes at that point, I believe, and then it's right after that he encounters the defendant. So it's within that time frame.
Now, we say they match the description, but of course they don't exactly, because the description includes that the people were wearing masks. Now, of course, if you were wearing masks to commit a crime and you walked out of the scene of the crime, you might well take the mask off so that you don't look like a bandit on the street, although there seems to be a lot of that these days, masks on the street. So now we have a description, and I understand why race is a obviously more sensitive part of a description, but this doesn't even include the race. This is 3 people dressed in black. Is that specific enough? I mean, if he'd said just 3 people and he'd run into 3 people, would that be enough? Do you see what I mean? Like, it's just not much of a description. I agree, these are 3 people dressed in black, but...
Yes, it's not much of the description, but it's in line with some of the cases that I cited in my brief. There are some pretty vague descriptions that will get you reasonable suspicion. So yes, you just have to look at everything together. Okay, so you just have to take that, as you know, we have to take that with the temporal and geographic proximity, and we have to factor in other things such as flight, and make that calculus, And as we know, these are really fact-specific cases, and you just have to look at these cases with that in mind and compare each fact to each other case. So that's all I could say to that.
Can you get there without the roofer, do you think?
I don't think you get there without the description. No, I think if you don't have the 3 black males, I'm sorry, the 3 males wearing black clothing, you don't. I think you would not have enough. So time here. Oh, we have 6 minutes. Not sure if there's anything else I wanted to say. Just want to make sure that, pick something up here. I think the Robinson-Vader case is a case that the court could look at. It's in my brief. I don't remember the page number. It's decided in 2023. There's reports of gunfire near Boston headquarters. The description is only of 2 black males wearing black hoodies. So the officer encounters the defendant.
This is before Warren?
This is after Warren.
Okay.
So the 2 black males wearing black hoodies, they're riding bikes, okay? And the defendant is eventually encountered within proximity to the crime scene shortly thereafter, and he is not on a bike, but he is a black male, and he is apparently wearing the hoodie. And the court, looking at that, I think I'm sorry, there is also the additional factor of this defendant was looking over his shoulder and repeatedly as the cruiser approached him.
I remember that
yes.
case. Yeah.
So we have that case. I think that's a pretty good example of what Your Honor what I was trying to explain to Your Honor, that the descriptions can be quite vague, and there's other cases in which there are similar vague descriptions that pass constitutional muster post-Warren.
Do you have a case that says that if you feel something hard, you can take it out of a pocket because it might be a weapon, anything hard?
I did cite a case, Commonwealth versus Blevins, in which police officer felt something that was hard and took it out, and it turned out to be a weapon, a gun, but they didn't know what it was. I would point out in this case, Your Honor, I think it's a semantic issue about the frisk. In my brief, I said that the officer just grabbed the defendant, and in doing so, pulling him out of the car, he felt something hard in his right jacket pocket. That essentially was a frisk, even though in my brief I said it was not a frisk in the sense that the officer was intending to uncover evidence of a crime or whatever, but he did what you would do with the frisk. So why do it again? We know that object was wrapped inside the mask, or I believe it was, when it was pulled out, so it was covered with cloth, so the officer would not have uncovered anything by a pat frisk. He would not have dispelled his suspicion. He would have still been faced with the hard object. So I think that's a red herring, the whole frisk thing, and having to go through that formality, if you will, after you've already essentially done it, pulling him out of the car. So I think that's all I have to say. My theory is always less is more when I speak, so. Before I get myself into trouble.
I see no further questions, so thank you very much. Very good argument. Very helpful, both of your arguments were. So thank you. And the case is submitted.
Very good.
Our next case is also partially impounded. It is number 24906, and I don't know the scope of the impoundment order, but hopefully counsel will tell me if I'm allowed to say the name of the, I don't know what he is. Petitioner. Your attorney Caffrey?
Yes, I am.
Is the name of the petitioner impounded or no?
No, I don't think so.
Okay, so this is number 24906. Waylein versus Commonwealth, and we will hear first from you, Attorney Caffrey.
Thank you, Your Honor. May it please the Court, I'm Attorney Caffrey, and I represent the petitioner appellant. Firstly, the court violated due process when it excluded the release and discharge plan prepared by petitioner's social worker. The major issue before the court was, or before the fact finder was, would the petitioner reoffend? And without that release and discharge plan being before the jury had an unbalanced view of the evidence, the same type of unbalanced view that Santos cautioned against. This report was factually important. The petitioner had a low score on the static 99. He scored a 1 or a 2 depending on which examiner scored him, which is an under 10% reoffense rate. The main issue in the case was the dynamic risk factors, and as part of those dynamic risk factors, The question is, was he going to remain in Massachusetts, or was he going to move with his girlfriend to Kentucky? That was discussed by the qualified examiners when they were talking about the dynamic risk factors. And the report prepared by the social worker spoke directly to this. It ID'd shelters in Salem that the petitioner could have gone to. It ID'd mental health counseling resources for the petitioner and Lynn. It ID'd primary care services in Salem for the petitioner. This piece of evidence spoke directly to whether or not he was going to remain in Massachusetts or move out of state, to live with the support who the qualified examiners did not think his girlfriend would have been a good support. This spoke directly to sort of the main issue in the case.
So I think, counsel, the challenge for you is not whether this evidence would have been useful for your client or perhaps persuasive to the jury. The challenge is that it was hearsay. And as I understand, Santos, the Supreme Judicial Court provided, sort of expanded the hearsay exemption for psychiatric and psychological records that were prepared by experts. And at trial, both before and at trial, counsel, I understand it was not you, trial counsel said that this social worker was being presented as a fact witness. So there was no claim at trial that this report was the sort of report that is contemplated by Santos. And as I read the transcript, there was also no objection to the decision the judge made that the witness could testify, but that the report couldn't come in. So how, in your view, do you get over those two obstacles?
Well, I'll start with the second part of that question about the objection. I think the case law is clear that a motion in limine preserves the issue for this court. So the court, trial counsel proposed to admit the report, and the Commonwealth opposed the objection of opposed the admission of the report. Trial counsel objected to that, and the court overruled them. So I think that preserves the issue. As to the hearsay issue, that's a more complex issue. There's different parts of the hearsay question. The first part of the hearsay question is the statements in the report by the providers. Now, the social worker testified to those at trial without objection, and she should have been allowed to testify to them without objection, because those are simply statements of intent or state of mind as to what people plan to do or what they could do or what they thought they could do for the petitioner. Those are statements of intent. They're not hearsay. The second hearsay objection raised was whether or not this was prepared in litigation. And Santos sort of disposes of that when it says basically that's just because a report or documents were prepared in litigation in these type of in anticipation of litigation in these type of cases, that does not automatically render them inadmissible.
Okay, but Santos, just to get back to Justice Hershfang's question, Santos is about expert reports. You didn't qualify this witness as an expert. You didn't say it's an expert report. You didn't say, so this expert report has to be admitted. What's your response to that?
Well, I think this is analogous to an expert report. Even if she wasn't qualified as an expert, she certainly is similar to an expert. I mean, she has qualifications. She's a licensed social
But all
worker.
she's describing, there is one sentence which seems like an opinion, right? There's one sentence in this report which says, in my professional opinion, these would be adequate to meet the needs or something of the petitioner. But then it's just it is facts. There's this place, and he could go there. There's that place, and he could do that. There's this third thing, right? I mean, it's facts. It's not an expert opinion, except for that one sentence, maybe.
Well, I don't think this case turns on whether or not it was an expert opinion. It turns on the fact that without this report being admitted, the jury would have had an unbalanced view of the evidence.
But all right, so I think Santos is about expert opinions, right? Because it lets in certain expert opinions of the QEs and the CAB. The statute does by its terms. And then, of course, people go and get an expert that says, no, so-and-so is not sexually dangerous, and then they want that in. This doesn't even opine on that question. That's what the expert reports that went in say. They say sexually dangerous. You can believe everything in this report, and you still won't come to the conclusion just based on that the person isn't sexually dangerous. It doesn't even say that, right?
Well, Santos talks about the due process issues inherent in these type of cases, given the evidentiary rules on this. Section 123A9 allows.
Can I interrupt for a moment? What I'm having a hard time understanding, and maybe you can help me with this, is that, trials aren't perfect, right?
Yes.
We can all agree on that. And in this instance, even if this testimony came in, I'm having a hard time understanding how this should have resulted in a reversal, right? In essence, let's just say she testified that they were going to live in Alabama versus Kentucky or Kentucky. Something wrong, right? But it's about a plan upon release. Had it come in, how would that have changed? And how its lack of coming in, how does that affect your client's due process rights when it really doesn't have anything to do with the ultimate determination?
Well, I think the Commonwealth can't show the exclusion of this was harmless beyond a reasonable doubt. This was, this case was not necessarily an open and shut case. There was certainly negative evidence against my client, but.
Sure, but this piece of evidence, best case scenario, would have just informed the jurors that my client may live in A, or he may live in B, or maybe C, right?
Well, it went beyond that in that it discussed the mental health and the medical treatment that was available to him here in Massachusetts.
Does that have bearing on sexual dangerousness?
Yes, it does, because the main issue is whether or not he would reoffend, and I would say whether or not he was continuing to go to counseling or getting mental health treatment. The jury could certainly take that as having an impact on his sexual dangerousness. Both parties discussed his future plans in closing argument. This was an issue in the case. The Commonwealth mentioned it specifically in closing argument that there were all these great options in Massachusetts for him, but we didn't know if he was going to stay there. Both the qualified examiner and I would also say the CAB report also testifies about future treatment options. This would be coming in to directly rebut some of the CAB reports. Everyone was sort of talking about what he was going to do in the future, but the jury sort of lacked the actual black and white written report as to what he was planning to do in the future. And that petitioner's argument is that violates due process. Now, the jury was deprived of seeing some of the petitioner's evidence, but the jury also the Commonwealth also introduced evidence, discussed facts that weren't in evidence in their closing argument. The Commonwealth encouraged the jury to speculate regarding potential offenses that didn't happen and the potential reoffense stats. Again, the key question here is whether the petitioner would reoffend. And the Commonwealth went beyond the qualified examiner's testimony when it discussed the reoffense statistics. the qualified examiner, when she was questioned about whether or not the reoffense statistics were an understatement or they underestimated, she said, "We really don't know." And in its closing, the Commonwealth encouraged the jury to speculate that these statistics were an understatement and that because of underreporting and that the petitioner would reoffend. They also speculated about offenses that didn't happen. They speculated that he would have continued to offend it, that the petitioner would have continued to offend it against the second victim if he had been caught. There was nothing in any of the evidence that discussed that. It was...
Well, why isn't that fair response to the argument in closing of the petitioner, which is, and the second thing, it's just a one-off?
Yeah. Well,
When, of course, what happened is it's a one-off, maybe because he was arrested that afternoon.
The Commonwealth is certainly entitled to respond to the closing argument of petitioner, but they're not able to go beyond the facts of the case in responding to it. And there was no testimony here that he would have likely reoffended against that victim. That was beyond the facts that were in evidence. The jury wouldn't have been able to fairly consider the jury was unable to fairly consider whether or not petitioner would be able to reoffend after they'd heard this closing argument, and because they were lacking the key piece of evidence that was the centerpiece of the case, the social worker's report. So a petitioner, this case should be reversed for those reasons.
Can I just, I had a question reading your brief I was hoping you could help me with. I can't quite tell whether you are saying that it was error for the judge not to give a Wyatt instruction. Is that part of your appeal?
Yes, it is, Your Honor. It was in this case, a Wyatt instruction was necessary because the Commonwealth began its case by stating the petitioner remained a sexually dangerous person. That, in this case, under these facts, a Wyatt instruction would be necessary to deal with the prejudice that resulted from that statement.
And are we reviewing that for substantial risk?
I would say this is a preserved error. The Commonwealth, the petitioner asked for a Wyatt instruction at the motion in limine hearing, and that preserves the error. But I would say even under a substantial risk of a miscarriage of justice standard, that reversal would be required because there was no Wyatt instruction given. It was necessary, again, to get the jury necessary to correct the prejudice from the opening statement.
Thank you.
I see my time is almost up if there's no further questions.
I see none. Thank you very much. Very good argument. We will hear next from Attorney Mansfield.
Good morning. May it please the court. Brian Mansfield for the Commonwealth. As regards to the report of the social worker, again, as the court pointed out, the social worker was not identified as an expert. In fact, she was identified on the joint witness list as a fact witness. The offer of proof that petitioner's counsel made during the motions in limine that she would not be offering an opinion on sexually dangerous and in fact not be offering any opinions at all. She would just be saying what was available if he were to be released in the community in the way of housing, financial support, mental health, and sex offender treatment, if he chose to participate in those activities. She was allowed to testify. She testified to that, what was available. She testified about where he might live or where he might stay if he stayed in Massachusetts, although that was an open question whether he had moved to Kentucky. She talked about if he stayed in Massachusetts where he might get mental health treatment, medical treatment, and sex offender treatment. And the Commonwealth's witnesses, both the qualified examiners, or one of the qualified examiners was provided the report beforehand from counsel for the petitioner and did consider it and said, it was not a protective factor in and of itself because of the high degree of risk that the petitioner presented with as it was. So the Santos case, again, as the court has pointed out, was dealt specifically with expert opinion and expert reports that went to the issue of whether, in that case, Santos was a sexually dangerous person. And because the qualified examiner and the cab reports are admissible by statute, the Santos court found that then the petitioner's experts should also, as a matter of due process. But again, this was not a witness. I mean, not an expert. This witness was not an expert. As far as the statement in the Commonwealth's closing that we don't know what would have happened had the petitioner not been arrested after the second offense, again, as the court pointed out, that was in direct rebuttal to both cross-examination of one of the qualified examiners and to an argument made in closing by the petitioner's counsel where she was trying to make the point that in the first offense, the petitioner offended for over 2 years against a child on a monthly basis, and that in this case, which this offense happened about 10 years later, the petitioner had served some time in prison, but it only happened once, and was trying to say that was some sort of a de-escalation in the offense. The big difference being the child in the first offense did not report it for 2 years. The child in the second offense reported it that day. The petitioner was arrested, and he's been either held pretrial, held under a prison sentence, or been civilly committed ever since. So he's not been in the community. And there is case law that says when the law enforcement interrupts the conduct itself, that doesn't say anything about the underlying condition that caused the offending. So this was a perfectly appropriate response to the closing argument of the petitioner. As far as the charge for that there is a presumption of not sexually dangerous, the Wyatt case says that that is not required. It's not error to give it. It's not error not to give it. This jury was instructed, I believe it was 17 times, that the burden on the Commonwealth was to prove that the petitioner is, currently is, or is now a sexually dangerous person. So the jury could not be left with any thought that it was anything about the present day that they were considering the dangerousness. As far as the comment by the Commonwealth in opening, I believe was that the petitioner was a sexually dangerous person, and then the Commonwealth went on to list the evidence that would be shown to prove that point.
I've read that opening. I think there's a pretty strong argument it shifts the burden. Now, I understand it's not an instruction by the judge, but it begins by saying, this is a sexually dangerous person. He has been found sexually dangerous by, I guess, a jury 3 years ago.
And that is an element of sexual dangerousness that the Commonwealth must prove in Section 9.
I agree with that, but I read the whole opening. And by the time I'm done with it, I'm left with the impression that counsel is saying, if you can find that anything's changed, let me know. And that's really not what's supposed to happen here. The defendant, or whatever he is, respondent, doesn't, petitioner in this case, I guess, doesn't, is that right? Petitioner, I think, doesn't have to say, doesn't have to prove that something has changed. The burden remains with the Commonwealth. I mean, my guess is openings are like this quite a bunch in these cases, given, as you say, what has to be proved. If I thought that it was an invitation to shift the burden, how would I analyze that?
One, I don't think that it did shift the burden. what the Commonwealth said was that he presented with a chronic and enduring condition that cannot be cured, one that can only be treated, and that the evidence would show that that condition had not been treated. In fact, there was recent evidence to show that that condition was still quite strong and that the petitioner had been caught both with pictures of young females within the prior year, very young females, and also a handwritten list of websites, many of which showed.
No, if it had been phrased the way you're phrasing it, it would have been fine. It isn't quite phrased that way, you know, and we will show that this is, you know, that the condition is still there and is strong or whatever. But it wasn't really phrased that way. So my question is just the one I just asked a minute ago, which is, if I thought that it was an invitation to shift the burden, how would I assess? It's not an instruction saying shift the burden, but it's an argument.
Well, again, I believe that the opening did just say what the evidence would show.
Is it structural error if I think that, or is it, was there an objection? Is it substantial risk? How do you measure something
It would have to
like
be a
that?
substantial risk because there was no objection to the opening, and the judge did instruct the jury 19 times that the burden of proof was on the Commonwealth and the burden of proof never shifted to the petitioner, and instructed the jury that the petitioner did not have to prove anything, did not have to call witnesses, and could sit there and not say a thing. So with that instruction, even if there was any likelihood of burden shifting from the opening, the judge's instructions were crystal clear that the burden was on the Commonwealth and never shifted. And if there are no other questions, the Commonwealth will rest on its brief.
I see none. Thank you for an excellent argument.
Thank you.
Thank you both. Very helpful to us. And the case is submitted. Our next matter is number 24811, John Doe number 524656 versus Sex Offender Registry Board. This too is an impounded case, and I trust the council will adhere to the scope of the impoundment order. We will hear first from Attorney Gautier.
Good morning, Your Honors. May it please the Court. Edward Gauthier arguing on behalf of John Doe. First, I'd like to get one issue out of the way, and that's the Factor 2 issue with repetitive and compulsive behavior. As this Court knows, a trial court judge struck down its use for risk of reoffense because the science doesn't support it. It's our position that the science doesn't support it for use in degree of danger either. The SJC addressed this year. It found that because the science was not admitted before the hearing examiner, that they were going to pass on the issue, and the issue will continue to be passed on until such time as an individual appears before the board with the right science to show that this is an unconstitutional application of Factor 37. I will admit and acknowledge in this case that the science was not put in before the hearing examiner. So that being said, I'd like to move on to another issue. Issue number 3 is the issue of the denial of motion for funds. And in this case, we have an offender who sexually offended for a period of 3 years against his biological daughter. She's an adult now. This individual has no history of abuse prevention orders or criminal harassment prevention orders, no criminal record of any kind. He was a model prisoner completing every program. And one of the most important things when we assess the future risk and danger of an individual is why did they sexually offend? In this case, the attorney for Doe before the board asked for an expert to address or to explore the adjustment disorder with anxiety. It's the only thing in the record that may tend to explain why this individual committed a sexual offense that seems entirely—
Your argument, though, seems to prove too much. Your argument, as I understand it, is anytime someone has a diagnosis, it's not up to counsel to articulate for the court anything about how it even might, by supposition or anything else, how it might affect risk of reoffense and risk of dangerousness. Rather, the mere existence of the diagnosis warrants an expert, and that seems too broad to me. You didn't put in, and you don't here put in, any even supposition or sort of logical inference or implication of how this might affect what the court is deciding, and I don't see how without, I mean, even if you said something that was wrong, the court at least would be like, well, I don't know if that's right or wrong, I see what you're saying, right? But you didn't put anything in.
I agree that counsel before the board did not put in any evidence that would suggest a link.
Or any argument, even. I understand if you don't have the evidence. You just say, well, adjustment disorder means blah, 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 and when one commits a violent act, it's blah, blah, blah. So maybe this affects that. Nothing.
So the DSM defines it as a development of emotional or behavioral symptoms in response to an identifiable stressor occurring, which would then cause him to act in a certain way. And I agree, it would have been better if counsel had put in some scientific evidence that linked adjustment disorder to some behavior.
An argument even. If he'd said, and so, because he did blah, 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 we can infer that blah, 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 and an expert has to let us know if that's right. But there's not even an argument. There's just he has a diagnosis. Could I have some funds?
The only argument I can make at this point is not just the adjustment order, but everything I mentioned. It appears that this might be something that would have caused him to act in a way that's completely inconsistent with his character. But the other thing I would say is, after practicing criminal law, which I will admit is very different than appearing before a board, I've had many motions for funds allowed with as little as what Your Honor just described. And I understand it's a criminal context, but I could walk into court and say, my client appears a little off to me, Your Honor, funds. With the board, it is much different, of course. We have to somehow, without having an expert first, explain to the hearing examiner, without expertise, we're not doctors, we don't know these things. We have to explain to the hearing examiner, this is what adjustment disorder is, this is how it might offend his sexual risk of offending, without having the funds to consult with an expert.
But counsel, and nice to see you, counsel.
Good to see you, Your Honor.
I mean, there's a difference, right? So in the criminal context, when criminal responsibility or competency is an issue, put an affidavit and say, I'm having difficulty communicating with my client, or there's something, my personal observations. Here, it's not like, the board just hands out checks, even reasonable amounts of $5,000 without some sort of relevance, right? So if, for example, your client had bulimia, okay, it's a mental illness. And I don't mean to be uncaring, but so what, right? Why would the Commonwealth of Massachusetts and taxpayers pay to somehow find out from an expert whether bulimia might cause someone to sexually reoffend? Because I don't think so, right? There's no connection. And so here, there has to be something other than just to say, he's got a diagnosis of adjustment disorder. It's not a very high hurdle, but it's something.
It's something. I understand, Your Honor. Just circle back. As an attorney, I can tell a judge in a criminal case without having any expertise that I'm having trouble speaking with my client. My client seems a little off. I've looked at the facts of the case. They seem to present with somebody who might not be thinking clearly. But in this case, I don't know enough about adjustment disorder. If I were counsel to argue
You didn't put in here that your client or whoever was the lawyer below didn't put it in, my client is acting bizarrely, and I feel like an expert might be warranted. They just said he has this diagnosis, but I've made my,
I understand.
you know,
The only
suggestion.
thing I would say with this versus bulimia is that the DSM-5 does say that this adjustment disorder does lead to behavioral symptoms in response to identifiable stressors. And I'm not going to say that's enough to push us over the finish line, but it's something more than an eating disorder. This is something that actually has stress and then behavior in response to stress. And I will move on with acknowledging that more could have been done at the hearing to explain to the hearings examiner exactly how this disorder might link to risk of reoffense and degree of dangerousness. Briefly, I'd just like to discuss the factor 37, which was a research article that was put in. It's a 2004 article from Dr. Hansen, who's an expert in the field. And in applying this research article, the hearing examiner didn't give it any weight because he applied it only to factors 29 and 30, which are offense-free time and age. Those factors don't apply. There's no offense-free time, and age is not an issue here because the doe is only 42. The issue, though, is that...
Although you argued age below.
Excuse me, Your Honor?
Although you argued age below, or is counsel below argued age, right?
Well,
Because he got some, I mean, minimal or not, I don't know what he got. I mean, it's not,
it's not.
60 is where it started, right? So-
42 is not, doesn't matter, really. I mean, the difference between 30 and 42 is
All right,
negligible.
but go ahead, I'm sorry.
But the crux of this is it goes directly to this case. We have an offender, a man who sexually offended against a minor girl, his daughter, biological child. The research that was introduced by counsel goes directly to the fact that the chances of recidivating for an individual in this circumstance, a father, biological female child, is the lowest of any and all offenders who are contact offenders. The lowest of them all, 6 to 9% over 5 years, and that is something...
Including prepubescent victims?
It's limited to male offender, incest-limited female victim. That's the essence of...
Okay, I mean, because there is a factor that puts the risk up if it's a prepubescent victim.
Well, factor 3 deals with an adult offender and a child victim, and it is allowed to be applied with higher weight if it's established by the board that the individual is a prepubescent victim. This is something we go back and forth a lot with the board because what is a prepubescent victim? There's always an assumption of an age cutoff, but I think they assume that any girl or boy under 12 is a prepubescent offender victim without.
Okay, but to get back to just the article, I thought what the hearing examiner said was that what is cited in this article in support of this is another article that was taken into consideration by the board. And I thought that was why the hearing examiner didn't rely on the article as additional information.
Looking at the quote from the decision, it appears that the hearing examiner focuses on advanced age with minimal weight. He is 42. Offense-free time in the community, there is none. The hearing examiner really does not go into any discussion about how the research on incest-limited male offender, female biological daughter victim impacts the assessment of Doe's risk of reoffense or degree of danger. The only other specific argument beyond substantial evidence was the use of the stable 2007 and the static 99. The statute, of course, as the court knows, imbues the board with expertise. That said, hearing examiners themselves are not doctors, they're not experts. Our position is that these diagnostic tools should not be relied upon unless they're understood. And I would point out that the stable 2007 was given as a part of a treatment program, and there were a series of recommendations, and Doe completed those recommendations. I believe I have covered the arguments I intended to make. If there are no further questions, Doe would rest on his brief.
Thank you very much. Excellent argument. We will hear next from Attorney Haynes.
Good morning. James Haynes on behalf of the board. Is there anything that the court would like me to start with, or shall I?
Your time.
All right. Well, so I would suggest that the hearing examiner's decision classifying Doe as a level 2 was supported by substantial evidence, and it committed neither errors of law nor abuses of discretion in its handling for the motion for funds or its consideration of his multiple rapes of a prepubescent child, his daughter, and it gave adequate consideration to the research regarding incest offenders and didn't give it short shrift. I would agree with my brother and thank him for not making me dwell on this point. I do think that the SJC's decision in September in 527926 pretty much covers what needs to be covered regarding the issue of repetitive offense as it's considered under Factor 37. I also agree with him that in this case, the question of whether or not the science supports it wasn't addressed below, and we should just follow the SJC's lead in this in saying, well, it's not ripe, we should wait until a case that is ripe to address that. So unless the court has any questions on that, I'm going to move on. I'm just going to follow my brother's order here. So in terms of the expert funds, I think that the main issue here is the question of whether or not Doe's attorney managed to prove the nexus, the need for it, because he definitely does identify a diagnosis that this gentleman has. It's adjustment disorder, but as Your Honor said, the question then becomes, so what? And I don't think it's insensitive to ask that. I do think that you need to be able to draw the point from A to B to say, we're sorry that you have this thing, but how does that actually, affect your risk of reoffense or your degree of danger, or is it entirely irrelevant? And again, here, the attorney below didn't establish that nexus. He, to his credit, he made a game attempt to do so. He did have Dr. Brown present something, an affidavit, but even the affidavit from the expert who would have opined on this really only gave us it might have something to do with it.
Do we have the Brown affidavit? I don't remember seeing
I believe so. I believe it is going to be in, most of this was, I think, at the Exhibit 9, around pages 34 to 40. I know that a number of the exhibits in this had to be resubmitted prior to this hearing, and I'm hoping that that didn't change the pagination. If so, my page sites might be a little approximate. I apologize for that. But yes, I believe what we got was a motion from the attorney at the classification hearing accompanied by an affidavit from Dr. Eric Brown saying he has this thing, it might have some relationship to his risk of
I see
reoffense.
the affidavit of the
Attorney.
and the affidavit of Doe, but I don't see.
If I misspoke, then I apologize. If it's simply an affidavit from the attorney, then I would suggest that that's again he made a game attempt, but that would be even less so than if he got something
We'll
from
look
a
and
doctor.
see what's there.
I'm sorry, say that again?
We'll look and see if the affidavit's
Yes,
in
yeah,
there.
I apologize if I thought that, I know that this attorney has used Dr. Brown for similar affidavits in the past, and I may have misspoken in that. But nevertheless, whoever said it, what they said doesn't really draw that necessary point, get you from point A to point B. And I think that that is where the hearing examiner decided that this simply didn't get you around to what you need. You hadn't met your burden to get the funds here, and I don't believe that that amounts to an abuse of discretion where the board's factors explicitly identify it in the first thing, that you have to not only identify something that's wrong with you, but also show how it will factor into the risk or danger assessment. And to briefly address the idea of the sort of the recursive, we need an expert to tell us whether we need an expert argument. Again, first of all, I think that does become a little bit circular. Secondly, it would lead to a situation where all you would need to do is identify any issue that the person had, tennis elbow, fear of heights, and at that point, effectively, the board would have to give you money, which I don't think is what the regulation had in mind. And finally, this court has actually explicitly considered that argument before and found it wanting. The case that stands for that is a relatively recent one. It is, bear with me here, it's a Doe 29663. That's 105 Mass App Court 1109.
So it's not a published opinion?
It's not a published opinion. It's a 2025 case. In terms of the research article concerning the incest offending and Factor 7, that one is a little bit more tricky. Actually, I will note that I think that the hearing examiner's decision specifically says, I looked at this and I considered it for age and for time in the community, and I don't give those very much weight because one of them's irrelevant. He hasn't been out in the community, and the other one I'm giving minimal weight because he's not very old. To classification counsel's credit, he did actually in his closing say that he also wanted it considered for age. So it would have been, I think, better practice for the hearing examiner to also have addressed it as it spoke to age. But again, I think this was my argument, not the hearing examiner's argument. The question of age that is raised in the 2004 article is derived from a 1998 article, the Hansen meta-analysis that gets cited a lot in our cases, and that is considered under Factor 7. So even if the hearing examiner didn't explicitly say, I'm considering this 2004 article for the issue of age, the information that it presents is something that has already been considered. It's the old wine has made it into the new bottle. We're not going to drink it from the new bottle. We've already drank it from the old bottle. Sorry, I kind of strained that analogy.
But really distracted me too. Once we start talking about wine, I'm kind of lost. It's very distracting.
I'm
the
sorry.
wine, I'm just saying.
Sorry.
So if I could get back to that, it
Yeah.
seems to me a little unfair, but maybe I'm misinterpreting it. Factor 7 of the board's regulations has an understanding based upon Hansen's reports from back in 1998 that, for what it's worth, that one of the lowest risks, an acknowledgement that one of the lowest risks are the type of offenses that were committed here, right? Biological parent, right, with a...
Incest offenses, at least, yes.
Okay,
I don't think it
so
subparses it
broader.
down to that. Yeah.
So to some degree, it's factored in there in that there's an acknowledgement when the hearing examiner is determining whether to give Factor 7, heavy, weight, or minimal, or whatever, then it's baked into Factor 7, right?
It is.
But isn't it a separate argument to say, okay, you need to look at the fact, separate and apart from Factor 7, that the type of behavior that I committed is one of the lowest risks to reoffend. In other words, not just that it's going to be held against me, but it's actually going to inure to my benefit.
The factors themselves do not go that far. They do not actually,
Right.
Yes. And in fact, this court has previously also said that that approach is not an error if a hearing examiner says, I am going to say that this is definitional, that it sets a floor, but I am not going to treat it as a basement. That is, bear with me here, the case for that is, it's 524553. That is 98 Mass App Court 525. It's a 2020 case. And again, I think that this sort of argument that it should not only be considered definitional, but it should be considered somehow risk mitigating was advanced. The the hearing examiner in that case considered it and said, no, that goes actually against the specific language of the factor, so I'm not going to do that. Frankly, I don't think that I can. And secondly, I just, I'm treating it as definitional. I'm not treating it as risk elevating, but that's as much as I'm going to do. And this court did find that treating it that way was not an error. So, I do think that there is previous precedent from this court that supports not treating the incest relationship as mitigating is all right. And then again, the other thing, it's a small point here, but because the only offending that went on here was incest, the hearing examiner didn't apply this factor at all. Sometimes they will say, I take note of it, it's only definitional. In this case, they just kind of left it off, but I would suggest that where the factor itself hasn't even been applied, any research that goes to an inapplied factor is in its way sort of irrelevant. But the main thing I would hang my hat on here is that even if this was error, I don't think that it was, but even if it were, it would still be harmless error because it would get you to this issue of the factor itself says that this can't be applied in a mitigating way. This court has agreed with that. So even if it had been considered, it wouldn't have gotten him to the mitigation. There just wouldn't have been something that he suffered as a result of it.
How does a prepubescent victim interact with that Factor 7 statement?
I do not know. In reading that, I've read the 1998. Oh, Gesundheit. I've read the 1998 analysis a number of times. I don't believe that it does subparse down to incest offenders who offend against adult victims versus minor victims.
So, and
I can
within the
that,
factors, how is the age of the victim or the prepubescent status of the victim accounted for? Which factor?
That was accounted for under Factor 3, and it was given increased weight because, again, the hearing examiner found that the offending here started when the victim was about 10 and went to about age 13, and we consider anything under 13 to be prepubescent. I don't believe there was any.
They found that the child was 10 at the time it started.
Yes, I believe that is, yeah. I'm thinking if there's anything else. Again, the use of the stable and the static, the actuarials under Factor 35, again, I would suggest that that was done appropriately. I believe the hearing examiner explicitly said that she didn't rely on the ultimate risk opinion, and the reason for that is the language of Factor 35 specifically says that they're not supposed to, unless the author of the report appears to testify and says, I conducted these things, here's what it is, and provides sort of live testimony as to why they thought that the ultimate risk opinion was correct. The hearing examiners typically just say, well, I will consider these as they are good sort of information regarding the overall assessment, but I'm not going to say that, well, because he got a 0 on the static or he got a 13 on the stable, that just ends the inquiry for me. It provides context as opposed to...
But I'm a little confused because your brother said that the hearing examiners are not experts who can read these things, and I had thought, well, it says what the risk is at the end, so how expert do you have to be? You have to read English, basically, but you're saying that those conclusions are not properly considered by the hearing examiner. Is that right?
They're not considered dispositive or binding, I guess I should say. If you get a static 99 and it says that this gentleman is very high or this gentleman is very low, that doesn't end the inquiry. The hearing examiner can take that into consideration. It can take the entire
and
scoring.
Can accept it as a true assessment by a validated tool.
Yes, I believe so. The only case.
So what can't, I don't understand. So where does it say they can't use?
So Factor 35 has language within it that says that you're not supposed to accept ultimate risk opinions as they appear. And this covers not just the treatment center evaluations, which is where these actuarials were done, but also QE reports, that sort of thing. They're not supposed to consider the ultimate risk opinion unless the person who drafted it appeared. There is also a separate...
Is that different from, you just told me it could be taken into account but can't be dispositive. Is that what factor 35 says, or it says it can't be taken into account?
The ultimate risk opinion shouldn't be taken into opinion. You can read the entire thing. You can read the scoring of the actuarial, say, I think
How
that
do you
was
know what the score means without the opinion at the end? A 13 is a high risk, a 0 is a low risk.
Well, I guess I would say that you can read the analysis and say, yes, I agree, this adds up to 13, and that under the tool is a high risk. But the fact that the tool says it's a high risk does not automatically compel the hearing examiner to then say it's a level 3.
I'll have to look at factor 35. What you just said
Sorry, I might not be
seems
articulating this very well. I
confusing.
apologize. I think the ultimate, because I'm running low on time here.
I'm right that the hearing examiner in this case said, one says low, one says high, so I put it in the middle.
No, actually, I don't believe that she did do that. So I don't, that's the thing, is the hearing examiner looked at both of these. One said it was high, one said it was low. The composite score in the evaluation provided by the treatment center said that it was in the middle. And the hearing examiner says, I do consider that, but she didn't then say, and that is why I am giving him a level 2. She considered it, that information in the context of the broader analysis that the board has to do, both of risk of reoffense and degree of danger. I guess the point that I'm probably trying to make somewhat in a bad fashion here is that if we get an evaluation which contains actuarials, the hearing examiner can consider them, but it doesn't end the analysis here. And I think my brother is trying to suggest that she saw that and that was the end of the analysis. That I don't think is what occurred here.
All right, your time has expired. I see no further questions, so thank you very much to both of you again for excellent arguments that were very helpful to us. We are going to take our traditional mid-morning break, and we will return in 10 to 15 minutes to hear the final 2 cases.
All rise. Thank you very much.
session. Please be seated.
Welcome back. Our next case is, again, an impounded case. It is number 25593. Because it's impounded, we will be using descriptors for the various parties, mother, father, child, etc. It is Department of Children and Families versus father. My understanding is that the appellees will be dividing their time 7.5 minutes and 7.5 minutes, with the department going first and the child going second. Okay, and then with that, we will hear first from Attorney Fabish.
Good morning, Your Honors, and may it please the state, may it please the court. Attorney Fabish on behalf of father. In this termination of parental rights case, father challenges the decision below terminating his parental rights because the trial court made errors of law or abused its discretion with regard to 3 essential aspects of its decision, whereby the trial court misconstrued an expert report and testimony. It used father's failure to relocate back to Massachusetts as conclusive evidence of unfitness, and it failed to appreciate father's continuing progress towards completion of his service plan and insights gained into the risk of involvement of mother with the child. But before I get to those issues, I do want to quickly address an issue raised in the state's brief regarding waiver of father's arguments. The initial brief that was filed in this matter had citations that were erroneous and miscalculated. There was a letter filed pursuant to Rule 16L that clarified the citations, and based off the clarification of the citations, our position is, as argued in the brief, that the arguments that were raised in our reply brief were in fact preserved both at trial and in the initial brief before this court.
So can we talk about that for a moment?
Yes,
because I appreciated the 16L letter. It was lengthy, right? But I'd rather an attorney, and so thank you for coming forward and saying these aren't correct, whether the pagination is off or just the numbers, whatever. Here are the correct ones. Assuming now, instead of looking at some of the sites and saying this couldn't possibly be what you're claiming as error, in order for appropriate review, an appellate review, to occur, aren't you required to identify specific findings of fact or conclusions of law that you believe were erroneous, and then argue? So in other words, if all the numbers match up, which I'm assuming that they do now, thank you, you still haven't identified. It's like, oh, inadmissible hearsay. And I'm scratching my head saying, well, which one of the numerous findings of fact or conclusions of law are you challenging right now? And so there's the problem that I find, is that how is this not waived?
Your Honor, with respect to the inadmissible hearsay argument, and I should note for the court I'm successor counsel on this case, so I did not file the initial brief.
Yep.
With respect to the inadmissible hearsay argument, we have no problem waiving that portion of the argument. The arguments that
So you're no longer arguing that there's inadmissible hearsay?
No, Your Honor.
Would have been nice to know that before piling our way through it. I was going to say, you didn't change any of the citations except in the factual section. So I've been looking around trying to find what hearsay you're talking about, and there's no way to do that. But if you're not pressing the point, then
And so I would ask the court, Your Honor, to focus on the arguments that were raised specifically in the reply memorandum. Those are the arguments that we believe are preserved.
The expert report, the father's failure to move that was improperly weighed, and the failure of the judge to consider father's progress since the and kind of movement toward realizing mother is a risk.
Yes, Your Honor.
Okay, thank you.
Turning to those issues, the first is the trial court's, we would argue, improper use of and misconstruction of the expert report offered by father. Specifically, that report found that father suffered from no area of intellectual deficit that would be likely to grossly interfere with decision-making, judgment, learning, or attending to the affairs of day-to-day living, i.e. nothing that impacts parenting. The expert also specifically cautioned that his recommendations were intended not to imply that there was some requisite threshold of treatment or mental health functioning that would be necessary for him to achieve prior to reunification with the child. Instead, the expert emphasized that the recommendations that were made were intended instead to allow for the father's fulfillment and increase his harmonious relationships with individuals. The trial court, in contrast, used the conversation of father's avoidant coping mechanism contained in the expert report to suggest that there was a predictive value to that resulted in father's unfitness that would be likely to continue to a near certitude. This was despite the very clear limitations that the expert himself put on his report. The doctor also specified the question of father's psychological traits in relation to his ability to maintain boundaries with mother. The trial court, in its decision, found repeatedly that father struggled to maintain boundaries with mother. Instead, the expert opinion clarified that that was not, in fact, an inability to maintain boundaries with mother, but was justified and explained by other psychological traits that father had.
So I want to talk to you about, time is short, and I want to talk to you about only one issue. The judge couldn't have made clearer in both the preliminary decision and in the findings of fact and conclusions of law that issued later, that if father had not maintained a relationship with mother, he would not have been found unfit continuing into the future. What do you say about that? If that's the critical thing, the rest of this is, you may be right, you may be wrong, but unless you have a solution or response to that, and he clearly maintained contact with the mother, and the case starts with him, the New York order, which is about the mother, then leaving the child with the mother, whether it was for one day or whatever, but that's what happened, actually moving back in with the mother for whatever reason, despite this New York order. And then he, earlier the court says, look, I'm not going to say it's going to continue into the future. And then it continues into the future. And then the rights are terminated. Is there anything to be said about his continued contact with mother?
I think there is, Your Honor. I would suggest that it's addressed primarily in Section C, starting on page 16 of our reply brief. The overwhelming facts of the case establish that with the exception of this continued transportation of mother to a supervised visit with a mutual child that they maintained in Pennsylvania, father had essentially no ongoing relationship with mother.
He had a child with her.
Another child.
Another child with her. I think that may have involved some contact between them.
The critical inquiry, though, Your Honor, is as of the date of the review and redetermination
How many,
hearing.
what day was the latest child born?
I apologize, I don't have it in front of me, Your Honor. It was, if memory serves, it was after the initial hearing, but well before the review and redetermination hearing. And again, the critical inquiry is as of the review and redetermination hearing. That child in Pennsylvania is the child that we're talking about. And father maintains contact only insofar as he's transporting mother to and from the visits.
But the judge didn't believe that, right? I mean, so that's a credibility determination that was made by the judge who considered the testimony, right?
Except there needs to be other record, where that's the entirety of the record testimony, and where the judge faults father.
They had plans to get married and were living together in New York. Then later she has a baby he thinks might be his, and then subsequently she has a baby that is his. There's a long period of continued contact with the mother, and that's what the whole case, in my view at least, reading what the judge says, that's what this whole case is about.
except that by the time that there's the psychological evaluation and by the time of the review and redetermination hearing, those incidents of contact have reduced to the point of being limited to that issue of transportation. And in the expert's report, there's an explanation as to why father maintains that position.
And what is the transportation that he's providing?
He's essentially picking up mother from somewhere and transporting her to the visit in Pennsylvania. And then
He lives in Albany.
Yes.
So he's picking up mother somewhere, maybe in Albany or maybe in Massachusetts, and driving with her all the way to Pennsylvania.
He is a courier, and so he regularly, my understanding from the trial testimony was regularly drives through Massachusetts, New York, Pennsylvania, and related states as a part of his job as a courier.
But it has to be believable testimony, right? I mean, didn't the father testify that he didn't even have mother's contact, and so somebody would contact him and let them know where mother was, and that was the only contact that he had?
At one point, that's true, Your Honor.
Okay.
But father also...
Go ahead.
Father also testified on the stand and admitted that he knew that mother had problems staying clean. He testified that it was due to those very problems that he had helped her to enroll in a drug treatment rehabilitation program in Pennsylvania. He agreed.
But my point being is that you want us to rewrite what happened and say that based upon this evidence, we believe father cut off contact other than giving a ride across 3 different states to visit their child. That's what you want us to do, and we can't do that.
I don't think it's a question of credibility determination, Your Honor. I think it's a question of quantum of evidence. And the state bears the burden of producing the evidence of an ongoing relationship between father and mother of such a nature that it poses a threat to the child. And again, we have a development of insight over the course of these cases. That's what these cases are about. These cases are about participation in services and acquisition of insight into relative risk to the children.
And so father testified that about insight. Can you point to me to father's testimony that would give this court the belief that the judge improperly considered his lack of insight?
Father testified in transcript 344-15 that he was resistant to doing Al-Anon services because he was not in a romantic relationship with mother anymore. Father specifically testified he wasn't worried about mother's harm to the child in Pennsylvania because there's supervisors at the visits at transcript 347-11 through 12.
He wasn't worried when she'd go out to the car, being in the hospital and coming back out?
Again, because there's supervisors at the visits. So there's just as...
No, but he wasn't concerned about substance.
I don't think he indicates that he's not concerned about substance use. I think what he says is, by the time of the review and redetermination hearing, he admits that mother was not currently sober, that, again, that's why he helped her enroll in a program, and that he did not have any intention or desire to co-parent with mother. He did not want an ongoing relationship with mother. What he wanted to be able to do was tell his children, and this is in the expert's report, he wanted to be able to tell his children that he didn't give up on their mother as far as, seeing that they would have a mother.
Do we factor in that he didn't move to Massachusetts? I mean, he has no home plan in Massachusetts, right?
So, I'm sorry, Your Honor.
Do we factor in the fact that father did not move to Massachusetts?
I think the court overly weighted the question of moving to Massachusetts. This case is distinguishable from Knox and from Zayden in a number of ways. Most specifically, that in this case, father had an established residence in New York for an extended period of time. He was a homeowner in New York. He had a mortgage that he was relatively close to paying off in New York. This is not the case of somebody who's transient and could pick up roots and very easily replace them in Massachusetts. And so the question becomes, does the court have the authority to require an ICPC, or is there an obligation on the court and the department to fashion some sort of an available remedy under the department's obligation and the court's obligation to oversee reasonable efforts which include the ability to supervise an out-of-state individual, particularly where that individual is close enough to the Massachusetts border that it would be possible for a Massachusetts social worker to drive out or to contract with a New York social services agency that could provide the type of supervision and reassurance that the court and/or the department was looking for. I do see I'm running very short on time.
You acknowledge that your reasonable efforts argument wasn't raised below, correct? In a timely fashion?
Not explicitly, Your Honor, but I do believe that the argument that the ICPC should not be an impediment and that the court and the department had an obligation to figure out some other mechanism.
Well, I thought the judge said custody because of the ICPC. But again, the judge was quite clear that if there were no relationship with the mother, the rights would not have been terminated. So for what's sort of at issue, right, at the moment of the trial, I don't think the failure of the ICPC or the living in Albany was the deciding factor, because the judge said they weren't. The judge said the deciding factor is the relationship with the mother.
I do see I'm out of time.
Your time, but I don't know if that warrants a response, because more of a comment than a question, but if you want to respond, you can.
Simply, Your Honor, for the reasons otherwise elucidated in our brief, we would request that the decision terminating parental rights be overturned.
All right, excellent argument. Thank you very, very much. We will hear next from Attorney Bayless.
Good morning, Your Honor. Your Honors, Robert Fairbairn on behalf of the Department of Children and Families. Your Honors, the Department's contention is the trial court did not err when it found a father who maintained a relationship with a mother who was actively struggling with substance use disorder, and showed in the 19 months between the initial adjudication of the child being in need of care and protection and the time of the termination of parental rights trial showed no appreciable increase in his parenting or understanding that the trial court properly terminated their parental rights. Your Honor, the primary emphasis in the trial rested almost entirely on father's contact with mother. Father gave birth to a subsequent child after the initiation of the proceedings, and the proceedings began when father, who had obtained custody for a child who was twice removed by New York Child Welfare Services and had a specific custody order that said he was not to have contact with mother, left the child in the custody of mother, and the child was then subsequently left unattended. Your Honor, at the first trial, the trial court noted that father did not like insight but did not find he was indefinitely unfit. Further, that the issue becomes at the time of trial, father had made no appreciable gain in insight.
When you say at the time of trial, you're talking about round two.
Yes, I'm sorry, at the time of the termination trial, Your Honor, the subsequent review and determination trial. Your Honor, the services father was asked to engage in were services that were actively available through the state of New York. They included individual therapy, which father at the time of the first trial, and this factored into the court's decision at the initial adjudication trial in January of 2023, that father had just begun therapy through the Veterans Administration, was engaging in a Nurturing Fathers program. And the court credited that in determining whether or not he was indefinitely unfit. When we fast forward 19 months later, at the subsequent termination trial, Your Honor, father was not engaged in therapy. There had been a lapse of several months. He testified that he did not gain anything from therapy, that he gained no insight. He sat and talked about what things were doing. Further, Your Honor, that one of the other requests the department had was engaging in Al-Anon, and father said he didn't need it because he wasn't in an active relationship with an individual struggling with substance use. Even assuming that statement were true, those services were designed to gain father insight into why he maintained a relationship with mother that placed his child in jeopardy, and he still lacked that understanding. Further, when it came to testifying about his relationship with mother, Your Honor, father was deemed as evasive and not providing truthful information. His testimony was that, and I think the court notes this in finding of fact 20 and 21, that his testimony was that mother would have a friend contact him, and then he would come get her and bring her to the visits that were weekly. And I think the court appropriately used its discretion in determining the credibility of that statement. In reference to the expert report, Your Honor, the expert report is cited quite a bit in the findings of fact. However, Your Honor, I think they're oftentimes used to provide context to the judge's overall understanding. The judge repeatedly emphasizes father's own language, his own demonstrated behavior, his own demeanor, and says his own expert uses the expert opinion to sort of weave that into to further buttress his argument. He's not improperly.
And I think, I mean, today we learned that that argument is waived, right? If you're talking about the alleged misuse of the
Yes, Your Honor.
51A and B reports.
So, Your Honor, overall, the trial court did not abuse discretion in any manner, shape, or form in this matter, and that it properly concluded that leaving the child in father's custody would place the child in imminent danger of abuse or neglect, that he was unfit, and that fitness would continue indefinitely into the future. And if there are no further questions from the panel, the department rests on its brief.
Thank you very much. We will hear next from Attorney Driscoll-Weiss.
Thank you, Your Honor. May it please the court. Roberta Driscoll-Weiss on behalf of the subject child. My client will be 5 years old in March. She has spent 4.5 years of those 5 years in substitute care and has been with this current foster family since September of 2022. That in and of itself is every reason to uphold the judgment and decrees of the trial court, because stability in the life of a child is important, and it is the best interest of the child is of the paramount concern. But there are many more reasons why this court should uphold the judgment of the trial court.
The judge didn't rely on that.
She didn't. She noted that the child was being appropriately cared for in her foster home, and that placement with the foster parents and adoption by the foster parents was in her best interest. This would have been the easiest case in the world for father to resolve. All he had to do was say, I made a mistake. I left my child with a woman with substance use disorder that is not properly managed, and I shouldn't have done that, and I will never do it again. But he never came to that realization. He blamed DCF for removing the child after he took it upon himself to leave the child with mother, who then left the child alone in a house, subject to a police response of a child being left home alone. He never came to that realization, and then went on to have another child with mother, then went on to facilitate mother's engagement in visitation with that other child at the same time when she would leave the hospital, go sit in the car, and come back because she was, feeling stressed out. But it never crossed his mind that she might be going into the car to abuse drugs and come back and expose their second child to that similar behavior. Father argues that DCF should have come to some sort of an arrangement with the Albany or the New York State Child Welfare Agency to engage in some sort of oversight so that he could have had custody of the child with him in Albany. But this is a man who, for almost 2 years, refused to engage with DCF, wouldn't meet with them, wouldn't talk to them, wouldn't let them in the home. When they initially said that they had to view the child, the social worker witnessed him place the child in the car and evade the department rather than engage with the department. So there was no reasonable expectation that any sort of departmental oversight, whether it was Massachusetts or New York for that matter, was likely to improve his understanding of how to keep his daughter safe.
Does the family with whom the child is placed right now, do they remain a pre-adoptive resource?
They do. Very committed pre-adoptive resource.
And when was the last time you saw the child?
I saw the child in person over at the end of the summer. I'm in quite regular contact with the foster mother, and we communicate quite often. As a matter of fact, she is sending me pictures today as we sit here.
But you haven't seen your client since the end of the summer?
I saw my client in August, Your Honor, at the foster home which is in Western Massachusetts.
I assume that this is the judgment about what position to take in the case is a matter of substituted judgment?
It is, but I will say that I spent a fairly lengthy period of time with my client at the home, asked her what I believe to be age-appropriate questions about.
Well, she's 5, right, or
True,
4, right?
true.
So-
Although, you know, some 5-year-olds are remarkably aware of what's going on. But I will say that she's been there since 2022, and this is, quite honestly, I think the only home that has had any, you know, any period of stability for her. This is it. This placement with this family is the only period of stability that she's had.
Is she enrolled in school?
She is. She's enrolled in preschool and in an inordinate number of after outside activities.
I mean, I know this isn't in the record, but I'm interested
I
in the
expected
question.
the question, Your Honor. And I should have come armed with the full list
No,
of
that's fine.
extracurriculars, but I didn't. Suffice to say that they are numerous and pink. As I say, this, you know, somebody who's been doing this for the length of time that I have, you know, some of these cases are inordinately complicated, and this one just wasn't. All father had to do was open his eyes to the reality of the harm that mother posed, that mother's substance use, ongoing and entrenched substance use disorder presented to the child. Even if he couldn't actually see it in their encounters, he witnessed it firsthand when she left the child alone in the house and went down the street to talk to a neighbor. I'm not sure what more a father would need to see or experience than that. And yet, he never came around to believing that that situation had occurred. He believed through trial that mother had simply been on the deck having a cigarette and that the police had somehow failed to observe her. This was not even a close call for the trial judge, and I think her findings and the record amply support the termination of father's parental rights and the approval of her pre-adoptive home as an adoptive placement, and I encourage the panel to uphold the judgment, decrees, and orders issued by the juvenile court. If there's nothing else, I'll rest on my brief.
Thank you very much. Excellent arguments by all three of you, very helpful to us. These are, of course, our most difficult, or at least among our most difficult category of cases, so thank you very much. The case is submitted. Our final case for today is partially impounded. I trust you will adhere to the impoundment order. It is number 24-1209, PR Realty LLC versus SCHAJNOVITZ. And we will hear first from Mr. SCHAJNOVITZ. You're not a lawyer but are appearing pro se, is that right?
That is correct, Your Honor.
Okay, so my guess is you'll be very nervous, but we'll try to be as nice as we can. So with that, we'll hear from you.
Good morning, Your Honors. May it please the court. My name is AMIR SCHAJNOVITZ. I'm the appellant.
Can you move the microphone a little closer to you so we can hear you for sure? Go ahead.
Like I said. Good morning. May it please the court. My name is AMIR SCHAJNOVITZ. I'm the appellant. I'm appearing here pro se today. I'd like first to introduce the main core reason for this appeal.
Oops. No, that's me doing that.
This case,
Sorry, I'm just having a hard time hearing you, but maybe if you lean into the microphone. Thank you.
Yeah. So this case arises from a summary process trial that was fundamentally distorted on the eve of trial, the housing court dismissed two statutory counterclaims quashed all of my subpoenas, and then refused to instruct the jury on the governing tenant protection statutes. I'd like to divide my argument today for three, to discuss and present, and I hope it may help the court to understand my appeal better if I just put it into three, the most core issues. So the first one is the housing court's April 30 order dismissed 2 statutory counterclaims and quashed all of my subpoenas on the eve of the trial without proper notice or analysis. Second, the court then refused to instruct the jury on the key tenants protection statutes under Chapter 186, Sections 15, 15A, and 15B, based on that same misunderstanding of the law. And third, those rulings, combined with sweeping evidentiary exclusions and a pattern of prejudicial conduct by opposing counsel, left the jury with one-sided record and denied me a fair trial. I'm asking this court to reverse the judgment, reinstate counts 3 and 4, and remand for a new trial. So, with a bit
Now,
more...
you say 3 and 4, but I thought the judge said that at least 3 was subsumed within quiet enjoyment. I understand that, and that was a Section 14 claim, not Section 15B, if I'm not mistaken. So was the count 3 actually tried as part of quiet enjoyment, or it wasn't?
It wasn't, so the count 3, it's basically, I was not allowed to even raise it. It was dismissed. I was not allowed to raise count 3 and count 4.
Well, you say it was dismissed. The judge certainly said, and I'll ask opposing counsel about this, certainly said, I've read the papers and I conclude there are only 3 claims. And it did seem as though, therefore, the judge was saying, I don't see any facts supporting counts 3 and 4, or something like that, and so they're not really going to be heard, even though it wasn't technically an order of dismissal. But I thought that at trial, the claim under Section 14, the judge said it was part of quiet enjoyment. Am I misremembering that?
Respectfully, that was the misunderstanding of the statutory framework. The fact that the same conduct may also violate Section 14 does not erase the separate protections remedies in Section 15, 15A, and 15B. Massachusetts laws allows multiple overlapping statutory claims to be presented to the jury where the fact supports them. So there was no analysis of the facts. The hearing that you referred to, Your Honor, was held at the eve of the trial. And this is actually, the other party had 6 months. I served my counterclaims 6 months prior. So instead of challenging my claims then, they proceeded with discoveries. When I gave them the discoveries at that time, I disclosed all the subpoenas, all the witnesses, all the facts, and yet they proceeded to try to strike my jury demand, which led to a session here in the single justice to reinstate the trial. Then 10 days before the trial, there was a pre-trial hearing with the first justice, a different judge, the first justice of the Central Court, where we both submitted our proposed jury instructions, and that was also an opportunity to do that. So I believe the last-minute hearing, that was just with 1 business day notice, basically violated due process requirements. And I'm not speaking about separate issues. I'm talking about the cumulative effect of this altogether. I'd just like to state that the starting point of the April 30 order, the docket entry says order, but in substance, it is clear it dismissed counts 3 and 4. I wasn't allowed to present those 2 counts the way I planned, I planned to call witnesses and present evidence. It was all under the quiet enjoyment breach, which was basically, it was not reasonable for me to prepare a new strategy. I also would like to explain that the trial was set for Tuesday, April 30. On the Friday before that, I received notice of the hearing on a Monday, the eve of the trial. Although the transcript shows that on the eve of the trial, during the hearing, the judge already, for the record, states that he's not going to allow me to present those issues or any documents or any information about, basically, which is important for my presentation. And I appealed on the record. I already refused to that. The next morning, on the morning of the trial, before we even the jury were called for impanelment, the judge, right from the first day of trial, the judge gave us the order, entered that same day. It also contains mistakes of the facts, misstating my divorce case and misstating the facts over there. But if you look at my principal brief, I filed 2 briefs. Principal brief was very concise, only speaks about what happened in that morning and the day before. The addendum to that brief, if you look at it, it was basically the order and papers that the judge gave to us on the morning of the hearing, meaning he gave us his view of the statement of the case, what he wants. He already framed the facts that he wants the jury to find. He didn't allow, basically, me to present my...
What evidence exactly were you prohibited from presenting?
So it was basically subpoenas. It was medical records and it was education records.
I'm sorry. Say that again. It was.
I was basically prohibited from introducing any evidence concerning my minor child, my daughter, my only
I thought
child.
you were prohibited from bringing any claims on her behalf. Were you also excluded from presenting any evidence?
I was excluded from presenting any evidence concerning
And what
her.
evidence is there that is relevant to your counterclaims?
So, for instance,
Because you don't really point that out in your brief, and that's the question.
Yeah. So it was I believe it was count number 3. It was the unlawful eviction without process. My daughter was pulled out of school in the middle of the year, and basically she was just evicted without process, and that was
She was evicted.
Correct, Your Honor.
Okay, but the judge said you can't bring a claim on her behalf. So what claim on your behalf is that relevant to?
So that goes to, by not allowing me to present evidence and authenticated documents, it goes to my credibility before the jury.
But can I ask, you had mentioned just a moment ago medical records.
Yes. Medical record was minor, just because of her anxiety and problems that she had. But more specifically, what the presentation was about is the fact that she was pulled out of the class. And I had that record from the classroom, from the teachers, basically, showing that she was out of nowhere just pulled out of the class after she finally made friends.
And how does that affect eviction by force? Eviction from what? From the premises that the suit is about?
So yeah, it's all very detailed in my counterclaims. Yeah, I just would like to, if I may, go back to the core issue of the issuance of the order.
Okay.
I'd like just to say that ruling that finally disposed these 2 claims, and I timely appealed from that. I also like to say that due process problem was the hearing was held on the eve of trial, the Milan Mortis, and the order contains no finding or analysis, yet it removed both statutory claims and all evidence that needed to prove them. And that caused prejudice, because after the April 30 order, those statutory claims never reached the jury. And the witnesses and the records...
Yes, but the reason I asked you the question I did is, if you're not allowed to bring those claims because they are the claims of another person, your minor daughter, then of course they don't reach the jury, because you can't win because only she could win. She'd have to bring a suit. That's all I'm asking you. How were you evicted by force, or she was?
So the issue that I focused on my appeal was that specific order, that it was error. So
okay, but if it's an error, it has to still make a difference. Do you see what I mean? Like, okay, so let's say that was wrong, but then they went through the whole trial and it turned out it was your daughter's claim and couldn't be presented to the jury, then it might have been an error, but it wouldn't make any difference. Do you see what I mean?
I believe, I mean, the jury was supposed to basically to evaluate it. So the statutes give different remedies and different. So basically, if my claim were under 15b, for instance, the interest of the unit, for instance, there was also a case where the landlord entered to the unit while the lease was still valid and there was money deposited and removed all of my goods, and that goes under Section 15B.
So the eviction of your daughter was from your apartment?
These are yeah, correct. There were two separate issues. The fact that there was a forced eviction without...
And then entrance before termination.
Exactly that he entered, right after he entered the unit, took all of my property, changed the locks, I could not regain entrance. And that specifically goes under... specifically goes under Section 15b. For instance, Section 14, the quiet enjoyment, addresses landlord actions disturbing the quiet enjoyment. But Section 15b, for instance, specifically prohibits landlords from unlawful entry and unauthorized removal of tenants' goods before lawful eviction or lease termination. And the judge, in that hearing, like you stated, he said that the right of entry, entering wrongfully, and I'm quoting from the transcript, page 210, the right of entry, entering wrongfully, evicting you from premises, changing locks, removing property, all falls under breach of quiet enjoyment, but it's not true because that misinterpretation contradicts the established law under Simons and Solomons from 1982, which clarifies the distinctiveness between quiet enjoyment breaches and specific statutory prohibitions against unlawful entry and removal. Also by Lowry, also the same year, confirms that unlawful entry and unauthorized removal of tenants' goods clearly falls under Section 15b, not 14. And this mischaracterization prejudiced me by narrowing the statutory remedies under Section 15b and limiting evidence and arguments specifically relevant to unlawful entry and property removal. And because of that, that caused...
Can I know this may be challenging because I don't know what documents you have with you, so if you don't remember, that's okay, and I'll just figure it out. But 15b is very long, as I'm sure you know, and it has a lot of subsections. Do you recall which of the subsections your claim was under?
Yeah, so 15b I don't have it in front of me, that you're correct, but I do have the count because it's part of the record that I assembled. So the count states entrance of dwelling unit and removal of goods prior to termination of lease in violation of Section 15b. And I believe it's part of even the title of that section, specifically speaks about entrance prior to ending lease, removing of and changing locks.
It does. The reason I ask is because I think that the trial judge interpreted the claim as being under 15b subsection A1, which talks about language that is permitted in a lease, in a residential lease. And so as I read what the judge said at trial...
That was the mischaracterization, exactly. That's what I'm talking about, exactly.
Okay.
That was his misunderstanding of the statute, correct?
Okay, so that's helpful to me. So your position is that the judge was misinterpreting that statute?
Correct.
Okay.
Correct. And that basically, everything stemmed from that. So basically all the errors in trial basically stemmed from that very error. So if you ask me what is the most important claim, is that exact order that was issued on the eve of trial without giving me any chance to do anything about it.
I'm sorry to interrupt you, but I know your time is running out. I know that you are frustrated by not having been able to present your claim under the statute that you used in your counterclaims. You did, however, present evidence at trial about how the landlord came in before the lease was over, and you were able to make your arguments, just not in the way you had intended to. Am I right about that?
Correct, yes. Okay. But because they were not instructed, he refused to instruct them on those statutes, so the jury were not even allowed to consider that. So he made very clear that the jury only has to follow his instructions and his verdict that he prepared in advance. So they were not even allowed to consider that under that statute. So it was futile.
Your time has expired, but if you want to tell us one other thing, if you're not done.
Thank you, I appreciate it. I'd just like to summarize. I'm sorry. 1 moment.
And we'll give opposing counsel additional time as well.
So I just want to say that, just to summarize, that by refusing to instruct on those statutes, the court effectively directed a verdict against me on my statutory counterclaims without even letting the jury apply the correct law. And that refusal was not harmless, because proper instructions, like we just said, would have allowed the jury to consider whether the landlord attempted to regain or interfere with the tenancy in unlawful ways, whether their conduct fit the statutory definitions in sections 15, 15A or 15B, and whether those violations warranted additional damages or different findings. Without those instructions, the jury saw my case only through the narrow lens of the court, left them not the fully statutory protections the legislature provided. And this is also preferred. And I also just, very, very quickly, just to give my closing, is that unless the court, there was another issue, just very quickly. The third point is the subpoenas, the evidence, and the cumulative due process, which is the third piece that I talked about. This ruling played out in practice together with the court's evidentiary decisions and opposition tactics. So when the court quashed all of my subpoenas in a blanket way, it did not analyze specific documents or testimony. It simply barred entire categories or evidence, particularly evidence related to my daughter and my family's emotional harm, and third parties' record that would have repeated Realty's narrative about damages and my supposed bad faith.
All right, so I've given you a couple extra minutes. I think we're going to have to wrap it up, but we have your brief as well. Thank you very much. I think you've helped us a lot with your presentation.
Thank you so much for allowing me to appear today. I really appreciate it.
Thank you. We will hear now from Attorney Haligian.
Good morning, Your Honors. May it please the Court. My name is Ani Haligian. I'm here for PR Realty, LLC, the appellee here today. Just to briefly clarify, the parties had a motion hearing prior to the jury trial that was previously scheduled by the trial judge. The appellant had an ample opportunity to file oppositions, which he actually did. At that motion hearing, we heard third parties' motion to quash subpoenas. The appellant had served subpoenas on his minor daughter's doctor and for her medical records. The doctor's attorney and his ex-wife's attorney appeared to argue those motions. Those motions were allowed because these subpoenas, what he was searching for, lacked relevancy to this case. It's a very simple non-payment of rent case. The appellant also, not only was his child not a party to this case, but he had no standing to bring any sort of claim on her behalf. He did not have legal custody of his child at the time, and it seemed like this was a way to circumvent the Middlesex probate court's order to restrict him from gaining access to her medical records. At that motion hearing, we also heard the appellee's motion for judgment on the pleadings. That was denied in whole, which the appellant does mischaracterize, saying that it was in substance allowed. What the trial judge did was to prevent confusion of the jury for the next day and to clear up issues. He looked through the appellant's answer and found that the appellant made no allegations and asserted no facts relating to certain sections of Chapter 186.
That sounds a lot like dismissing those claims on the pleadings, whatever the title of the motion. It says denied in full, but if you look through the pleadings, you find no facts that support the claims in 3 or 4, and he mentioned the other 3 claims, not by number, but by description. Then effectively you've dismissed the 2 claims for which there's no evidence in the pleadings, no allegations in the pleadings. So that seems like a dismissal to me, whatever the judge wrote.
Yes, Your Honor. I mean, I would disagree that it's a dismissal because the counts, the trial judge made it clear that breach of contract, quiet enjoyment, and intentional infliction of emotional distress would survive. Those are his counts
Eviction
here.
by force is a separate separate phrase in the statute from quiet enjoyment. So presumably the legislature thinks those are two different things.
Yes, but under 15B, it's very specific.
14, let's start with, right, which is the first one, eviction by force.
So the appellant was able to bring that
As a quiet enjoyment claim.
as quiet enjoyment,
But-
correct?
But I'm saying the statute says there's two different things. It says there's something called quiet enjoyment, semicolon, eviction by force. So I suppose those are two different things. And it might not violate quiet enjoyment, but it might violate eviction by force, right?
Well, I would say that under 15B, though, it's very specific that it's relating to lease provisions.
15B, I'm talking about 14.
Under 14, Your Honors, he successfully testified and introduced exhibits for his claims. He was able to talk about.
But apparently he wasn't able to argue them the way he wanted because the judge had said there's nothing about eviction by force here.
Well, yes, Your Honor, but the trial judge has broad discretion over case
Well, not
management.
broad discretion to get rid of someone's cause of action.
No, Your Honor, but the judge does have the discretion to see that there is no facts asserted in his answer relating to that claim, and thus it would do nothing but confuse the jury.
And
of an
is the
irrelevant
reason there are
claim.
no facts in the answer because the person who was evicted was the minor daughter?
No, Your Honor, that is untrue. The minor daughter was not evicted by force.
Oh,
What
okay, but
happened is that
that's the
his
question. Yes, go ahead.
his lease ended March of 2021. He entered into a lease in 2020. His wife and his ex-wife and his daughter moved in with him.
Mm-hmm.
In July of that year, his ex-wife obtained a restraining order against him, which barred him from the apartment for a few months. At the end of that lease,
But
his
he was
wife-
still the name on the lease.
He was still named on the lease.
Okay, so it's his apartment.
His wife and his daughter moved out at the end of the lease term voluntarily, and they took their belongings with them. At that point, the appellant motioned the district court to amend the restraining order to allow him back in. The landlord then entered into a new lease with him as the sole tenant, and he lived there for another year paying rent. And then in December of 2022, he simply stopped paying. So his family was not evicted by force by any means. They voluntarily left at the
I
end of
have
the
no
lease
idea
term.
what the allegation, I mean, I'll look and see what the allegation is. Do you believe that he was prohibited from putting on evidence of things that happened to his daughter and his ex-wife, or only that he couldn't bring claims on their behalf?
The order is clear that he was only restricted from bringing claims on their behalf and any evidence that would support a claim on their behalf or any
Even if it would
damages.
also support his own claim?
Yes, but he alleges no facts that he was evicted from the premises
No,
unlawfully.
but I assume that if I rent an apartment and I live there with my child and the child is evicted, I feel like I probably have a cause of action, don't you think?
Yes, but you'd have to have standing to bring that.
And the standing would be that I'm the tenant, and this is who I had in my apartment, and they were evicted by force. Now, I'm not saying that's what happened, but that would be the allegation. And I don't understand why that isn't a harm to the individual that one of their family members was evicted by force. Do you understand why not?
I would say that I don't have standing to bring a claim for someone else. And if it's my child, where I normally would, but I don't have legal custody, I, again, don't have standing to bring.
Even if during visitation your child is at your house, which I'm not saying is the fact, you don't have legal custody, but you have visitation. The child comes to your house and is watching TV, and there's eviction of that person by force. Of course, I don't know what the actual allegations are. You don't think that the tenant has some right against the landlord doing that?
No, I would.
And of course, I'm not saying it happened. I'm just saying for purposes of whether a
course.
claim states a claim.
I believe that the guardian who has custody over the child would have standing to bring a claim over the child, not someone who doesn't have custody. It would be the
You
equivalent
think
of-
that a landlord can go in and kick out the guests of any tenant, even if they're lawfully there?
That's
And
not,
that wouldn't be eviction by force?
no, that's not, well, one, if they're a guest, it wouldn't be an eviction by force.
Why not?
Because guests are not tenants.
So, in fact, the landlord can come in and kick people's guests out? Because I've never heard of that happening.
No, I'm making the distinction that it's not an eviction by force. But regardless, you have to have some sort of standing to bring a claim for someone else.
Well, he's the tenant. It's his apartment.
Yes, but for one, my representation is that his child was not removed
Okay,
by
of
force.
course, of course, of
But the appellant himself was not there, was not living in the apartment. He was barred by a restraining order. So he has absolutely no idea what happened
He's the
anyways.
tenant, and he's paying rent. I rent an apartment for my daughter to go to college somewhere, but I'm in Boston, and she's in St. Louis. And she's kicked out of the apartment. Surely that's not okay, and I'm the tenant, and the person who I've allowed to live there is kicked out. That can't be okay, right?
Well, there's so much more that would go into that, Your Honor, as in, is this an authorized occupant? Is this someone who had permission to be there in the first place? Is this a trespasser? I mean, it delves into a world where that would need to be fleshed out.
Well, that's why you'd have a
answer.
trial.
Correct, Your Honor, but none of this is applicable. None of this is relevant here. The daughter is not a party in this case, nor is there any standing to bring a claim on her behalf. So this is irrelevant
Was that
evidence.
briefed and argued before the judge issued his ruling, the question of whether there was standing on the defendant's part
Yes.
to bring a counterclaim on behalf of a minor child?
Yes, the trial judge took judicial notice of the appellant's divorce case pending.
I asked if it was litigated. Did you argue, please dismiss these counterclaims because he has no standing?
I brought that issue up in the motion for judgment on the pleadings. I did.
Okay, and
then
did he reply to that?
He did oppose it, yes.
Okay.
Moving forward, Your Honors, the appellant also, I've discussed about his counterclaims. He also says that he was he was precluded from presenting counter evidence, cross-examining witnesses, challenging false statements. All of this is categorically false. He admitted into evidence actually more exhibits than the appellee did. He at length cross-examined both of the appellee's two witnesses, and he spoke at length and opined at length in both his direct examination and in his closing argument. So he in no way was prevented from putting on his case. He also alleges in his brief that appeals in his brief that the judge should have recused himself based on a reversed decision by the appeals court striking the appellant's jury demand following his noncompliance with use and occupancy payments. I find it to be unreasonable that one reverse decision would impact the impartiality of a trial judge, especially one that has spent countless opportunity ensuring that the appellant had a fair trial, giving him a lot of deference being a pro se litigant, allowing the appellee to stipulate to exhibits that weren't properly admitted. The appellant had a lot of grace by the trial judge, and I think that any reasonable, objective viewer would also agree with that. Lastly, the appellant takes aim at my conduct during the jury trial, stating that I objected many times and that I appealed to the jurors' frustration after this 2-day-long jury trial. I counted in aggregate, I objected 21 times over the course of 2 days. Most of my objections were sustained by the trial judge, and they focused on the fact that the appellant refused to refrain from testifying while examining a witness, and, God bless you, and he also refused to refrain from introducing exhibits that had been redacted. As for my strategically appealing to the frustration of the jurors, in supporting evidence of this, the appellant says that I thanked them for their time and understanding, which is nothing more than boilerplate language for a jury. And also, he conveniently omits the fact that he also thanked them for their time and understanding, as I think everyone should. They are the ultimate fact finders, and it's a longstanding principle that we uphold, thanking them for their service to this Commonwealth.
Can I ask you a question about the facts at trial? So just reviewing Chapter 186, Section 14, it, among other things, talks about a landlord attempting to regain possession of the premises by force without benefit of judicial process. Can you review for me what the facts that were before the jury at trial about the order of operations of trying to invoke judicial process, entering the apartment. Was there an entry before the eviction notice was filed, served?
No, Your Honor, there wasn't an entry. Like I said, what happened after his first lease term ended, his wife and daughter moved out, the apartment was empty. He then petitioned the court to be let back in. The landlord let him back in. There were actually police officers present as well. And then the parties entered into a new lease, which he paid rent for many months, and then seemingly stopped paying rent. After that, the landlord gave him actually almost a year before the eviction proceeding actually began to see if he would pay rent. It was brought in August of 2023, so about almost a year later. At no point did the landlord go into the apartment by any means, take his belongings, is storing them in some secret place. This is it is a fanciful story that's being told. And I believe that it's in part gone as long as it has because the prior property manager at the time is now deceased. So he's not here to give his side of whether he went in, but we have testimony on the record by the current property manager, his son, that no unlawful entry
Okay,
existed.
but this is a question. Allegations are made in the answer that did happen. Right?
Correct.
But that wasn't tried, was it?
Yes.
How was it tried if count 4 of the counterclaim was not permitted to go forward?
Because those facts that he alleged were able to be brought under 14. That's
Under
what it
quiet
actually is.
under quiet
Under
enjoyment.
quiet enjoyment. That is what the actual section Section 14 is the correct section that relates to the facts he alleges in here. The facts under count 4, have nothing to do with Section 15.
So your motion for judgment on the pleadings was filed 3 days before trial? 4 days before trial?
I can check the
April
document.
25th.
I trust Your Honors.
I'm asking because I don't,
Oh.
and your time's expired, but we gave your
Thank you.
opponent 2 minutes, so.
It was filed,
In any event, just days before, right?
I believe so,
And
but
then his opposition isn't on the merits, it just says it's too late to bring this, the trial's tomorrow, right?
I believe he filed a few oppositions, if I'm not mistaken. To all of the motions that were filed that
No, I'm
day.
asking about the motion for judgment on the pleadings. You're saying in the 4 days before trial, he filed many oppositions?
Yes, to motions to quash and to the motion for
No,
judgment.
to the motion, I'm only asking about the motion for judgment
Yes, he
on the
filed
pleadings.
in opposition.
But it was not on the merits, right? It just said, this is very late, the trial's tomorrow, this wasn't brought before. And in fact, the judge said, yeah, it's tomorrow, I'm not going to rule on this, right?
I don't have his opposition in front of me, but
Okay.
but the trial judge did previously schedule that motion hearing, and I specifically.
For, what do you mean previously? How long?
I believe that we had appeared in front of him either but the week prior, discussing preliminary matters for the jury trial.
And a motion for judgment on the pleadings was discussed?
And I specifically asked, yes, if we could be heard on that motion. And because we had motions to quash as well, they were scheduled, the judge heard everything that day before the trial in an effort to clear up any sort of issues before trial date. In sum, Your Honors, I humbly request that the saga be put to bed and that that you allow my client to recover possession of the property and also try to recoup the $30,000+ in unpaid rent that is outstanding. Thank you so much for your time.
Thank you very much. Very, very helpful argument to us. It's a confusing case for a number of reasons. The case is submitted. Thank you very much. I know it's probably difficult as a pro se litigant to come before the court, so thank you for doing that. And with that, the case is submitted. I'd like to thank the court officers and the court staff for their excellent assistance as always. And with that, we stand in recess.